If you expect to come to court and litigate certain issues like child support, parenting, or spousal support, don't expect that you'll get that litigation date right off the bat. In most cases, judges in family and divorce court will expect that the parties have made attempts to resolve before the judge will approve of or grant permission to set a litigation date. Here are some examples of methods of resolving outside of the court process. For example, you could try a four-way meeting. That's where you have your two lawyers and the two clients meet in an open forum and discuss things without prejudice in an attempt to reach a middle ground. Another example could be the parties seeking out private mediation from a certified mediator. And yet another example is something that's offered in Edmonton in the Court of Queen's Bench called an early intervention case conference, an EICC for short. At an EICC, the parties meet with a judge who gives opinions, information, direction to the parties in hopes that they will reach a middle ground. If the parties do in fact reach an agreement, the judge at an EICC has the authority to put those agreements into a court order, a consent order, which is then enforceable or binding on the parties. If after mediation or an EICC or a four-way meeting, the parties are unable to resolve the matters and are still at an impasse, then the judge is much more likely in a situation like that to give permission to set a litigation date. Now, it's not to say that some matters wouldn't automatically get a litigation date. For example, emergency matters. In those cases, a judge can grant automatically a litigation date. However, in my experience, most matters don't qualify as emergencies, so the expectation remains that the parties make attempts to resolve first. So, before you put your dukes up, ready to fight, make sure you make that attempt to resolve.